right, welcome everybody. I believe this is actually officially our 10th attorney lecture series, and we are welcoming back Rocky Pilgrim to teach us about starting your own law practice. And in this time, she's going to be talking about financial aspects in your law practice. So without further ado, let me go ahead and turn it over to Rocky, and thank you very much for joining us.
Absolutely. Good afternoon, everybody. My name is Rocky Pilgrim, and I've been practicing family law here in the greater Fort Bend and Harris County areas for almost 18 years now. It's my privilege to be speaking again here for the Fort Bend County Law Library for the Attorney Lecture Series. This is such a great program and a great event that's been put together. I just want to thank Andrew and the whole team for inviting me back again, because it's just such a privilege to be able to be part of this. I don't know if you guys know this, but the Fort Bend County Law Library is one of the best that we have here, not just in our state, but everywhere. The amount of effort, the programs, the initiatives, the resources that are available are just fantastic. So kudos to you guys, and thank y'all for doing that. Today, like Andrew mentioned, I am going to be chatting with you about one of the most important things that you are going to encounter in your legal career: money. As attorneys, we know that we owe a fiduciary duty to our clients and sometimes to third parties. We are attorneys because we are hoping to make some money. And so in every aspect of our practice, whether it's as lawyers or as business owners, we have, money is just going to be an issue that you need to be very cognizant of and very intentional about. Our fiduciary duty to our clients doesn't just come in our practice. It's not just in our representation, but it also goes to how we handle funds, how we handle their property, and how we handle them. And so our failure to uphold our fiduciary duties can result in penalties, not just in letting the client down or having them suffer some detriment, but we personally can suffer things, as simple as a reprimand, all the way to losing our law licenses or even criminal prosecution. And so this is something that should be taken very seriously by every attorney. And as this is geared towards kind of our newer attorneys or those who are going out into solo practice on their own or opening their own law practices, this is something that you really want to make sure that you're on top of from the get-go. There are a lot of subtle nuances that come when we're talking about finances and financial considerations with law practices. Because this is kind of an intro to this, I'm not going to get into some of the subtleties like fee sharing and things like that. Just please be aware that those are issues that do exist and that you need to be aware of them. I am going to touch on a lot of the larger, more general issues that come with running a law practice and some things you need to be aware of. And of course, at the end, we'll have some time to answer any questions that you may have, or you're always free to reach out to me directly. My contact information is on this slide. Now, let's see. Don't mess with my money. So the very number one complaint that we have as attorneys when grievances are filed have to do with communication. But I will tell you that the first one that will get you disbarred or get you sanctioned is going to have to do with money. The Texas Disciplinary Rules of Professional Conduct 1.14 is titled The Safekeeping of Property, and it describes how a lawyer must handle funds and other property that belongs in whole or in part to clients. Now, I'm not kidding when I say everybody understands that this is practice. Everybody knows that things happen, and clients are going to get upset, and things happen. But the sanctions, the serious penalties come when you're not keeping your money straight. And also, guys, we're in this to make money. So if you're not able to keep your books straight, if you're not being diligent about it, then it's likely that your practice is suffering as well. Note also, when we're talking about the rule, and I'm going to post it here in just a second, that the rule talks about other property. But really what we're focusing on here are funds. We're talking about money, deposits, things like that. You do need to safe keep other types of property, things like jewelry or stock certificates if they happen to come into your possession. I know as an amicus attorney, I've had to maintain passports every once in a while, and you want to make sure you have a separate location, like a safe or something to keep those in. But right now we're going to be talking about funds. And the policy behind Rule 114 is to protect the funds that don't belong to the lawyer. And this is going to seem like a no-brainer, right? Like the billing and accounting and all of the things that we're supposed to do, like duh, right? But remember, as you are working as a solo, as you have the deadlines that are coming in and the clients who are calling and those pleadings that have got to get filed, and oh my God, I've got an emergency hearing and we've got all of these deadlines and heaven forbid discovery. Sometimes the day-to-day operations and those, little accounting things or the little just routine things, you kind of push to the back burner and you're like, well, I'll get to it because the other things we have immediate deadlines on and they seem like super big emergencies. But if you let it go too far, it's really, really hard to catch up. And so I'm going to tell you now, and you're going to hear this several times through this chat, don't let your billing fall behind. Do not let your accounting, do not let your bookkeeping fall behind. That is something that you should keep at the very top of your priority list. I know this from personal experience. I know this from professional experience. It's just so important, and you want to make sure that you're keeping up with it, because if you don't have time to do it now, you're definitely not going to have time to do it later. So Rule 114, what does it say? We're safeguarding property. This is the actual text of the rule. I'm not going to read it to you. You guys can read it. What I am going to tell you right now, though, is if you do not have a copy of the Disciplinary Rules of Professional Conduct, download it. Download it right now. Like if you're watching this live, minimize this video. If you're watching this on the recording, hit pause and go into your web browser, Google Texas Disciplinary Rules of Professional Conduct, and probably the first thing that pops up is going to be the PDF of the rules. We have all sorts of new rules that have been promulgated this year. They're effective as of July 1st, 2021. So they are literally brand new. And everybody should have a copy of these rules. We all have a copy of our code books on the desk, but this isn't something that O'Connor's publishes, right? But it's right there for free. Google it, get it right now. Make sure that you read it. The second thing that I would like to point out is that every rule within the Disciplinary Rules of Professional Conduct have commentary. Our bar is self-regulated, which means that we join the State Bar of Texas. I know that there's some controversy about that right now, but we promulgate the rules, our Supreme Court promulgates rules, and we regulate ourselves. And there's no hidden agenda here. I know that there are other professions. I know that, for example, the mental health care field is not self-regulated, and their board does not support them in the same way that our board does. I mean, I know that a lot of times we feel like we get picked on, but we have a group of our peers who review any grievances that come through. And the goal is to really protect the client, but not set the lawyers up for failure. And so all of our rules of disciplinary, or the rules of disciplinary conduct, they all have comments. And the comments are super helpful in explaining what the spirit of the rule is, why we have these rules, and they provide actual specific examples of what's compliant and not compliant. There's no hidden gotcha here. Nobody is trying to set anyone up for failure. So take a look and make sure that you understand what's going on, because a lot of times we have people who are speculating what something means. We're going to go into a couple of those issues here in just a little bit. We have people who, are trying to do the right thing, but we have so many resources available to us from the bar. The goal is really just to promote an ethical practice that protects our clients and protects the attorneys. So I'll get off that soapbox just a little bit, but seriously, download the rules and read them. Okay, so Rule 1.14. It's really simple, y'all. Keep your stuff and the client stuff separate. That's it. Don't commingle. Don't be loose about it. That's their box. This is your box. And just keep it straight and keep it organized. That's the only goal of this room. We want to make sure that in the midst of our robbing Peter to pay Paul, and we're worried about these things, and let me just transfer those funds real quick and I'll do the bill later. We don't want that to happen. I'm sure that if you don't yet know, we all know those attorneys who just seem kind of disorganized and disheveled. They don't have their billing done right. It seems like they're always kind of struggling a little bit. I personally know of an attorney he was a great attorney who was just kind of a hot mess, and he didn't keep his paperwork together. And he passed away unexpectedly, and there wasn't enough money in his trust account to cover what was supposed to be in there. And so what happens? Those clients, they're stuck and they don't have the legal work done. And now they probably don't have money to go out and hire another attorney. And so the whole goal and the whole point of these rules is to make sure that you are protected as the attorney and you know what's going on and you're keeping your funds straight, and that the clients above all else and any third parties are being protected as well. So in terms of funding, how do we do that? Trust accounts. I know that we've all heard of trust accounts. We all talk about trust accounts. We have probably used them in other areas of our life. For example, escrow accounts with our real estate properties and things like that. They're used in all sorts of different ways, not just with attorneys. And so what is a trust account? It's just a singular account that's separate. It's interest bearing, and it's designed to hold funds in this situation that do not belong to the attorney. They can be designated as trust or escrow accounts. They must be used. Y'all, you have to have a trust account anytime you have funds that do not belong to the attorney, whether they belong entirely not to the attorney and entirely to the client, or whether it's mixed and part of it may belong to the attorney and part of it to the client or a third party. I cannot imagine any attorney that does not need a trust account. We're going to talk about that a little bit more here in a second, but I am hard pressed to imagine a scenario where you are a practicing attorney and you do not need a trust account. So if you don't have one, get one. So when do we use trust accounts? Like I said, literally anytime that you have funds that are not yours. And if you have funds that you have not yet earned, those funds are not your funds. So here are some examples of some funds that belong in a trust account. Any advances for fees and most retainers until those fees are actually earned. Funds that belong in part to the client and in part to the attorney. So this can be in contingency fee agreement situations where you may have a settlement and part of that is agreed to be part of your fee, and then part of it belongs to the client, those types of situations. There may be funds that are paid to you that you're supposed to just hold, and they're meant to be dispersed to the client or to a third party at a later time. Those all need to go into your trust account and be dispersed upon that triggering event. So these are some things that have to go into your trust account. Any advances on fees or any expense deposits. And we'll get into the difference with that in just a second. Any settlement money needs to go in there. If there's an overpayment on a bill, so your client owes you $2,500 on an invoice and they pay you $3,000, that extra $500 needs to go into your trust account. These are examples of funds that must not go into a trust account. And so when we say that funds need to stay not mingled, so do not commingle these funds, that means you don't do it like a just in case or you want to have a buffer. There's very limited reasons for why you can commingle funds. We'll get into that later. But generally speaking, if these funds belong to you, you do not put them in your trust account. Even if you're thinking, I just want a buffer or I just want to make sure there's enough, you do not mix them. So if you have fully earned the fee, that does not go into your trust account. So that $2,500 that belongs to you, if it's one check, then you pop it into your trust account and you immediately disperse that $2,500 out to you. Reimbursements for cost advances. So this is different from an advance on an expense deposit. So when you have already paid a filing fee. You have already paid the expert witness fee or something like that, and you are being reimbursed for that, then that goes into your operating account. It does not go into your trust account. If you have not yet paid the filing fee, you have not yet paid the experts, you haven't paid the mediation fee yet, but your client is giving you the money to do that in the future, then that does go into your trust account. Guys, do not use your trust account for any kind of business transactions, especially not if they have to do with you personally or with your business. The only transactions for your trust account should be deposits in and very specific disbursements out. And you need to maintain your records very clearly as to what's going in and for who, and then what's going out and for who. Now, the only exception, like I mentioned, is if your bank is going to require that there be a minimum balance in order to keep the account open, if there needs to be a balance in there to cover any fees that have been assessed. That is the only exception where you can put in some of your fees and commingle those in your trust account. This is going to be pretty rare that this happens because most banks who are familiar with IOTA accounts or with trust accounts are not going to have those types of fees, or those fees are going to be pulled from a different account. So be wary if you have a bank that is saying that you need to have a minimum in order to have this account open, or who's going to be charging you fees for it, because most fees are waived and there are usually no minimums on IOTA accounts. And you want to make sure that you're doing business with a bank that understands our attorney trust accounts and IOTA accounts. Speaking of which, I want to make sure that we understand the difference between IOTA accounts and just trust accounts regularly, because we kind of use these words interchangeably. People just kind of reference them back and forth as if they're the same, but we have very specific scenarios where we would use an IOTA account versus when we would use a separate trust account. I'm assuming that everybody has heard of IOTA accounts. If not, just be aware that the two terms are not synonymous. Every IOTA account is a trust account, but not all trust accounts are going to be considered IOTA accounts, even if they're used by attorneys. And so IOTA stands for Interest on Lawyers Trust Account. This is a specialized type of account where funds are pooled when they're either too small or they're going to be held for too short an amount of time for the amount of interest that's generated to justify opening an entirely separate account. The primary difference between these, other than the fact that a separate trust account is typically going to be used just for one client or one matter at a time, is who receives the interest. Because remember, this isn't our money. And so these are meant to be an interest-bearing account. So who gets the interest that's generated from these fees that we're holding on behalf of somebody else? It does not belong to us. And so what has been proposed and what we do now is all of the IOTA accounts are used to generate, it's not typically a whole lot, but to generate money for the Texas Access to Justice Foundation. And they take all of the interest that comes from all of our IOTA accounts to support those programs that provide legal services for indigent community members. I will just mention as an aside that has been challenged and found at least once to be unconstitutional. That was subsequently reversed, and so that is still what our IOTA funds are being used for. But with our current issues with the state bar and the constitutionality, that may come up again. The separate trust accounts are when you have a very large settlement or you're holding on to funds that are very large, and the interest that's going to be accrued then goes to that particular client or third party. And so they're held separately. They typically are going to be held for a longer period of time. And so the interest that accrues on that person's money belongs to them. Now, in terms of IOTA, that's going to be the most commonly used account that most attorneys have, because especially nowadays with the interest rates the way that they are, the odds of having an account or an amount of money that's going to generate enough interest to make it worth the extra paperwork and accounting requirements to have a separate trust account are very, very low. And normally we're just going to be pulling that money over. And so using the IOTA account is going to be the most common. We do have very specific reporting requirements for IOTA accounts. When you guys are paying your bar dues, you probably see the compliance section that asks you to check the box or to fill out the form with regard to your trust account. And that's because we need to make sure that the money is going to the right place, and that everybody is adhering to this requirement as we are instructed to do. As I've mentioned before, if your bank is not familiar with what a Texas IOTA account is, do not use that bank, y'all. If they screw something up and they're not in compliance, that means that you're not in compliance. And the state bar is not going to go after your bank. The state bar is going to ask you how you screwed this up and why is the paperwork wrong. And so make sure that you have a relationship with a bank and with a banker that you can trust and who understands what your needs are. The EIN that you use when you set up these accounts are never going to be for your office or for you if you're a sole proprietor. The IOTA account uses the EIN for the Texas Access to Justice Foundation. Whenever you open a separate account for a particular client or third party, then you're going to use their EIN or their social security number, because otherwise you're going to get issued the 1099 and you're going to have to report that on your taxes. And it needs to go to the people who are actually receiving that interest. Now, like I mentioned, it's going to be super, super rare, but, and this is something that I just learned, if you have accidentally placed funds that should have been in a separate trust account and just grouped it in with your IOTA account, then there is a mechanism by which the interest can be recovered back from the foundation. The forms and all of the information on how to do that is on their website, which you guys can find online. Now, let's talk just a little bit about earned and unearned fees, because this is an area where we do have some confusion. These are not yours until you've earned them. It doesn't matter what your fee agreement says, y'all. We can talk all day long about non-refundable deposits and this part's non-refundable, and your client can agree to it and they can contract for that, and it doesn't matter. The state bar, our disciplinary rules say that until these fees are earned, they are not yours. So, examples of unearned fees. And just to be clear, we have all sorts of different billing schemes, right? We have hourly billing where you are working on an hourly rate, you send out monthly invoices, hopefully, you bill that, you get paid. We have flat fee arrangements, we have contingency fee arrangements. None of this is going to be earned until the work is completed. The advanced payment of expenses that you deposit are not yours until you have paid that bill. The biggest confusion is going to be in terms of flat rate fees and non-refundable retainer deposits, which I'm going to talk about in just a second, because a lot of people think that they are getting those and they're not. But let's talk about unearned fees. Anything that the understanding is it's going to be depleted as you're billing, that's unearned until it's billed and earned. Flat fees, even if you call them non-refundable flat fees, they are not earned just because you're calling them non-refundable flat fees. And then of course, settlement funds, the rules, Rule 104D talks about the rules and the requirements for contingency fee agreements. that's a whole like section of its own, so I'm not going to get into it into too much detail. Just be aware that in terms of settlement funds, I'm going to get paid a contingency on whatever I recover for you, those types of things. That's where you need to reference the other rules. And I know that I keep saying this, but because it's such an issue and it comes up so often, it does not matter what words you use. You have to keep things segregated until they are earned. They are always going to be subject to refund. They cannot be deemed non-refundable by agreement. And I know that this is like, I'm painfully hammering this in, but this is one of those things where lawyers really try to come up with creative ways to get around it, to use different words, to come up with extra language. And it's just not effective, guys. And it's not worth that however little bit it is, however those few $1,000s are, it's not worth your reputation. It's not worth the hassle. It's not worth the grievance. Just understand that everything is going to be considered refundable until it's earned. So what about these damn non-refundable retainers that we all talk about and that we've all heard about and that we want to use? And like, what's up with that? I'm not telling you that they don't exist. I'm just telling you that it is really, really hard to figure out how to use them effectively. The rules are very specific. And part of it also is that we will interchangeably call our fee agreements retainer agreements. And because we use those words interchangeably, and because we like to pop in non-refundable clauses into our fee agreements, it creates this aura, right? Are the clients actually going to know whether or not they can fight to get these monies back? But there is an actual technical difference, and everybody needs to be aware of what those are so that you don't get sideways, because this is your livelihood. We've invested a ton of money and a ton of time into getting these licenses. So let's make sure that they're protected. So what is an actual non-refundable retainer? A true non-refundable retainer is a fee to secure the lawyer's services and remunerate him for the loss of the opportunity to accept other employment. Okay? A non-refundable retainer is payment to an attorney simply for taking the case, because it keeps them from being able to take other cases. The lawyer has to be able to substantiate the claim that other employment would probably be lost by obligating himself to represent this client. You can't just say it's a non-refundable retainer if you've never had more than 2 clients at a time, because you're not going to be able to show that you're turning away other business, that you're losing other business by taking on this case. And that is the threshold standard for something to be considered a non-refundable retainer. If this can be proven and it's understood, then the fee is earned upon receipt, and it does not go into the trust account, guys. Remember the commingling rule. This is earned upon receipt. Upon taking that case, you have earned that non-refundable retainer, and it goes into your operating account. A true non-refundable retainer is not a payment for services. It is compensation for the loss of business opportunity. Okay. So, when is money going to be considered earned? These are going to be earned when you're working on an hourly rate basis, when the work's done and you've billed it. You need to watch out for disputes on your fees. So a lot of times we will send out invoices, and the invoices will say, or our fee agreements will say something along the lines of, look, I'm going to be sending you a bill regularly when I do the work. When I do that, I'm going to pull that money out of my trust account because it's going to be considered earned, and you've got 10 days to dispute the bill if you've got any problems with it. Otherwise, you're waiving it. We can say that all day long, but again, we want to make sure that our clients are protected, that our community is protected, and not all of us are super scrupulous or ethical, and so we have to have some framework in order to protect these clients. So even if we have that wording in our contracts, just to be aware that those provisions may not be enforceable, and at some points, if there is a true dispute about your work or what work has been performed, that even if you've given the deadline's passed, and those disbursements have been made, then there may need to be a replenishment in the trust account if that dispute goes too far. Flat fees. Unless you put in specific milestones in your fee agreement, then your flat fee should not be considered earned, and this is the guidance from the state bar. The flat fee should not be considered earned until the end of the representation when all of the work is completed. And you've sent that letter saying, hey, we did everything, I'm done, and then you can consider your fee earned. That's probably not what most of us think. And there are all sorts of issues that can come up with that, which we'll talk about in just a minute. And then, of course, again, with the contingency fees, look at Rule 104 because those are going to be governed by that. And so, disputed funds. What are you going to do when your representation has been terminated for whatever reason, whether it's because you're like, I can't stand this client anymore, I got to go, or the client's like, I don't like you anymore, like, let's just be done. What happens if that happens, and what are you entitled to? Have you earned your fees? On a flat rate, have you earned your fees? What do you do in situations where a third party has paid the bill, like a parent or a boss or something like that? Not a third party that is owed money, but somebody who's just making a payment on behalf of the client. When you haven't used all of the fee deposit, or if a refund needs to be made, who are you going to write that check to? Your client who you have a duty to, or the person who wrote the check? And so just before we answer those questions, we have some additional trust obligations that I do not want to forget to tell you guys about. This is where we can kind of get into some of the like nitty gritty, but they're pretty straightforward. I know that it seems scary and you want to make sure that you stay in compliance, but here are just some of the additional trust obligations that you guys just need to be aware of. The reporting obligation. So we have the requirement to tell them that you opened the IOTA account, where it is, which bank it is, the accounting, and all of those sorts of things. If you guys make any changes to your bank account, say you were banking at Bank A and all of a sudden their customer service just tanked, or you got a great deal and you're moving all of your business accounts to Bank B, you want to make sure that you update all of that information with the state bar. And you're supposed to do it immediately, but definitely don't let your compliance deadlines pass before you update all of that information. Reporting requirements to the client. So if you receive funds for the client, or if they ask for an accounting, then you are required to give it to them. So if we receive settlement funds, or if we've gotten payments on behalf of our clients, then we have a duty to report that to them. Of course, they're going to know about the money that they've given us, but any of the disbursements that have been made out of those trust accounts, any of the payments you've made on their behalf, any of the payments that you've made against your invoices, all of those things need to be reported to the client, in addition to any specific requests that they may make about what's going on with their account. There is nothing in the rules that requires us to have written fee agreements. There's nothing in the rules that requires us to give them physical monthly invoices. There's nothing in the rules that requires us to give them a written accounting. As good attorneys, we know that we need to have written fee agreements and that we need to have everything in writing and documented, because that's really the only way that we can protect ourselves. But just keep that in mind, that the reporting requirements are there. After your representation with your client is terminated for whatever reason, the case is done because you finished it, finished midstream because you just didn't fit, for whatever reason, you still have to maintain those trust records for at least 5 years. This is one of the reasons why sending out a closing letter at the end of a case is really, really important, because then you don't have this weird, ambiguous, when was the case actually finished? You have a letter that says, hey, your case is closed, and then these deadlines start to toll. In rare situations where a client disappears on you, or you just can't reach them, sometimes this is a reason for us to withdraw from cases because the client's just gone AWOL. then you have to hold these unclaimed funds for at least 3 years before you can treat it as abandoned property. So you have to keep it in your trust account. You have to hold it for 3 years. Then you can treat it as abandoned, but then you still have to keep the records for 5 years after that. So just remember that your bookkeeping and your paperwork, you really, really want to keep straight. Rule 803, and this doesn't cover just trust issues, but this is a rule that we have in general. This is part of us being self-regulated, guys, and being self-regulated is really a privilege, like I mentioned before. And so with part of that comes the responsibility, even though sometimes it's super awkward or uncomfortable, we have an ethical duty and obligation to report professional misconduct of another attorney. It's very specific. Rule 803 is very specific under what circumstances that happens. But we have to do it, and that's one of the only ways that we can maintain the integrity of our profession. And so if you see somebody who seems like they're struggling, who seems like they're having some trouble, don't hesitate to reach out. We have lots of resources through the State Bar. We have lots of community resources. Now in our digital age, and with a lot of the social media networks that we've got, we have all sorts of resources to help people. And it's really not necessary to place the attorney in jeopardy and definitely the client in jeopardy. It brings the entire profession down and really causes people to question our ethics and the integrity of the entire bar. And so that's why we have this rule. We don't have any discretion if things fall under this and we know that somebody's doing this. We have a duty to report. We can get in trouble if we don't report. And it includes things like not handling your trust accounts the right way. And so if you have a situation like that, then just keep that in mind, that we do have that obligation. Now, operational considerations. And I don't have a whole lot of slides on this. I'm just more going to free flow. And I know that we had some questions that I saw pop up in the chat. But I'm talking a whole lot about the rules of disciplinary procedure and what we need to do. And hopefully I've scared you just a little bit about your IOTA and trust accounting. What does that mean in the real world? Because let's face it, we're trained to be attorneys. Very few of us have a business background. Very few of us have either a degree or experience in running a business. And so we don't have that training. We don't have the terminology even. We are trained to be attorneys and to help our clients and to be wearing our advocacy hat. And so we're kind of at a distinct disadvantage when it comes to the operations side of our business. But when you're opening up shop, like I mentioned before, y'all, we're doing this to make money. We want to help people. Very few of us become attorneys because we don't want to help the people in our community and we don't have a genuine interest in helping our clients. But that doesn't mean that we're not also permitted to make money and make a profit and to have our businesses serve us and the lives that we want to live. We're not placed in the mindset of running a business. We're placed in the mindset of being in a courtroom or drafting paperwork. And so suddenly when you have your own office, now you have to wear all the hats, right? There was a commercial when I was growing up down in the valley with this guy who owned a furniture store. And he said, I am the owner, manager, and janitor of Texas Quality Furniture. And when you own your own practice, that's what you are. You're the attorney, but you're also the person who has to be the bookkeeper. You're also the accountant. You're also the person who orders supplies. You have to wear all the hats. And so if you aren't very diligent or you don't know to set up your systems and how to set up your systems, it can be really overwhelming when all of those hats and all of the fires and all of the clients come calling, and then you need to stop and you need to pay the bills and wait, but I also want to have a life and I want to have my kids around me and I want to maybe take a vacation and have some fun. And so what can you do in order to stay in compliance, make this process as simple as possible, and be able to do all the things and to be all the things and accomplish your goals that you set out when you decided to open your practice? And so here are some of the considerations that I hope that you guys will really think about as you're setting up your offices. And I can tell you that the most important thing, especially if you are a new attorney or if you're just setting up your law practice, or even if you're sitting back and you're like, you know what, I really kind of want to rethink how things are going. Like certain areas are working really well and some are not. In terms of finances and accounting, how do we get this set up? It all comes back down to systems and structure. And so you have to be very deliberate when you think about your accounting framework. And I will tell you right now, if you do not have an IOTA or a trust account, that's the very first thing you should do before you take on another case. I cannot imagine, except for very, very few, very, very limited scenarios in which an attorney does not need an IOTA account. So if you don't have one, get one. Keep it separate. So at minimum in your law practice, you should have 2 accounts. I can tell you that because one of the things that we do is not have that business background, so we often are just paying out money as it comes in towards all of our operating expenses. Most people will only have 2 accounts, which is an operating account and your trust account. That's fine, and if that works for you, that's fine. I would encourage you to speak with a bookkeeper or an accountant to think very deliberately about your budget and your plan. Because if you set up separate accounts, for example, for your taxes, your payroll taxes, your recurring expenses that you know are going to come up. We know that we have to have minimum CLEs every year, right? We know we need to have at least something of a library because we have to be able to research case law and we need to be able to look up codes, right? So all of these things cost money if you want to grow your practice. And I'm going to encourage you with this. One question that I get a whole lot when I'm doing my business consulting with attorneys is, how do I know I can afford to hire somebody? How do I know I can afford to hire this person to come into my office? How do I know I can hire an associate attorney? And by setting up separate different accounts for that, you can make sure that you've got your money and where it's being allocated, as opposed to what happens to a lot of us where it just comes in and then it goes out, and at the end of the year your CPA will tell you whether or not you made some money, but that money may not necessarily have ever made it into your pocket. Just as an aside, I learned about the Profit First system. It's based on a book by Mike McAllowitz. I've been following that system. I believe in it enough that I have become a Profit First professional, and I bring that to the businesses that I work with. It provides a great accounting framework so that you know right away whether or not your business is being profitable. But you have to be very deliberate about it, or inertia gets the best of all of us. We get busy, the time passes, and the next thing you know, another quarter has gone by. Have I made my quarterly tax payments? Do I have a payroll system in place? Do I know where my money is going? And so when you set it up from the front end, then it's easier to monitor and track. I will tell you that billing is the bane of every attorney's existence. Unless you are purely flat fee, if you don't care about how much you're working, and you just do it that way, billing always takes up a ton of time, and it's something that none of us likes to do, but it's an absolute necessary evil. And so something that you really need to consider doing, in which, you know, because we get busy and we're chasing those cases and we're chasing our clients, and by the end of the day, you know, when we've had all of the hearings and the meetings, we're just exhausted. You have to very intentionally time block billing time and bookkeeping time. You need to know where your money is. Like I said in the beginning, the money is what matters. And it's not just the client's money and keeping track of the client's money, but it's keeping track of your money too. And what often happens is we chase more cases because our billing's not getting done, and we're staying on these cases that are not paying. They're not paying what you're working. They're not, you know, at the end of the day, by the time the case is finished and they owe a big bill, we all know how that gratitude wheel works, where You were the amazing ace, and then suddenly they could have done it without you, and you never get paid on your outstanding billables. And if you try to go after it, what are we all afraid of? Well, now we're going to get a grievance filed against us. And so if you do your billing often, you do it completely, then and you stay in the routine of it, that is less likely to happen. And I know that lots of us were kind of caught in a monthly billing kind of cycle or mentality. I would encourage you that even if you're sending your invoices out monthly, that you set aside at least half a day every week to make sure that the billing is complete, because we all have plans to keep up with it contemporaneously. It never happens. We all get busy, we all get tired. If you have a system for capturing your time and inputting that time, then that consistency is going to pay off in the end. We have all sorts of programs available to us now, all sorts of tools. There are a million, it seems, matter management programs who help you to maintain your trust in your operations accounting. These are not the same, y'all, as accounting programs like QuickBooks. So some of the matter management programs like Clio, Practice Panther, Rocket Matter, or something like that, all of those will help you to keep track of the payments that come in from your clients, the invoicing and the billing, and it will keep track of your two accounts. They're all mobile. You can input your time contemporaneously if you remember, and you're on your phone. It's so turnkey now. Utilize the program. Find the one that works for you, though, because honestly, programs like QuickBooks, which are true accounting programs, they're very, very good, and they can be adapted for use in a law firm. And I know some attorneys and some paralegals who utilize that for their billing. It's just so particular that the learning curve may not be worth it for you. But just play around with it. Talk with some people about what works for them and why it works for them. Don't just have them see like, yeah, it's fantastic, it works great, because what works for them may not work for you. But try a few out. I don't know any that don't have, test periods where you can play with it and see all of the ins and outs and the features. Hire people. Hire an accountant. Hire a bookkeeper. We are already wearing a ton of hats. You don't need to try to add that extra obligation onto yourself. That does not mean that you totally abdicate the responsibility for knowing where your money is and how it's being transferred. So even if you outsource or you delegate to a staff member the billing and everything, you still need to set aside that time every week to take a look at what's going on. The only way that your business is going to be successful is if you keep your finger on the pulse of it. Your goal is to make it so that it runs as turnkey without you being personally present as possible. But that is only going to maintain if you keep an eye on it. So don't abdicate, you can delegate, but just make sure that you're keeping up with everything so that if something does start to slip, you notice it right away and you can get that boat corrected. Probably one of the last things that I'm going to mention, and if anybody has any specific questions about programs or different operational ideas or things like that, I know, like I mentioned, billing is a huge, huge problem. I have some tips and tricks for that if anybody's interested. It's really just a matter of making sure that you make it as easy on yourself as possible. But we won't dig into that just too much, even though that is the main part of the financial aspect. The last thing that I kind of want to talk to you about in the few minutes that are remaining is emergency planning. And COVID kind of brought this into a real stark reality for many of us. I don't know how many of you knew attorneys who got sick or who became basically incapacitated over the last year and a half. But one of the things that you really want to make sure you have in place is a contingency plan in the event of your death or your incapacitation. And none of us like to think about it. We're really, really great at advising our clients and telling them how, prevention is cheaper than cure, and make sure you've got your paperwork in place because you don't want this to be horrible for your children or for your spouse or, things like that. And then we don't necessarily do that for ourselves. the state bar has always had resources available in terms of publications and different just toolkits that they've put together for people who want to exit their law firm, whether it's retirement or just a planned exit, and for also emergency planning. I know that when we had the floods a few years ago, that they came out with a whole bunch of resources at that time for those types of physical emergencies. But if something were to happen to you, are your books in order enough that somebody could step in and know exactly where everybody stood in terms of trust accounting and who owed what money and things like that? Um, is there anybody who has the ability to access your bank account, your IOTA account? I know that there was at least one friend of mine who went from being diagnosed with COVID to being intubated within a 3-day period. He was newly married. He didn't have any partners. He had a secretary, but she didn't have any banking privileges. And his wife, they weren't married long enough for her to be on any account. And so she had zero ability to access any of his funds. The clients, nobody knew who had the authority to even talk to the clients because remember, we still have duties of confidentiality. And so how are we going to make sure that the clients are being taken care of and protect this attorney's practice at the same time? And so take a look at the State Bar website. Be very intentional about what would happen to your practice if something should happen to you, and take advantage of those resources that are available. I know that very recently there was an additional task force that was put together to put together resources specifically for COVID type emergencies. So we now have the ability to designate an attorney through the portal that the Texas Bar has for us, so that there's another attorney who's designated who can handle our cases or who can step in. Make sure that you take the time to have the difficult conversations and find out who in your world is that going to be, and make sure that they know that you've tagged them and that you trust them enough to handle your practice if something should happen to you. I'm going to go ahead and that's almost about time. I'm going to go ahead and wrap up now. Thank you so much for this opportunity to share these thoughts with you guys. Thank you again, Andrew and Jonathan. I always enjoy spending time with y'all and being able to chat and work with you. I hope that you guys have found this information helpful. And I am going to stop sharing my screen now and see if we can find any questions in the chat or anywhere else. Is that how you guys want us to do this?
Yeah, I've given everybody permission to unmute themselves. So if anybody has any questions for Rocky, go ahead and ask.
I do see that there was a question from one of the participants, Andy. What tips are there for tracking and billing time? And also, he mentioned this, but this is true. Anybody who has any suggestions, you're welcome to chime in. I will tell you, I'm pretty old school in how I keep track of my time. I have tried to do all the fancy things. I am old, and so I tend to do things analog because that works better for me and I remember it better. You know, all the studies that show when you write things down, you tend to absorb them more. And so trying to keep track of my time electronically, sometimes it works. I use Clio as my matter management program. They're honestly pretty much identical now across the board. But I keep a spiral notebook. This is going to seem so silly. I have a spiral notebook. I carry it with me all the time. Even when I'm going on home visits or something like that as amicus, I have a code that I use for my clients. So if I'm in public, people don't necessarily know who I'm talking about. And I've got codes for, you know, drafting or telephone calls or court appearances and things like that. And I just shorthand my notes, write how much time it took, and then I take those notes and I input them into my matter management program. I did this in the beginning. I switched and I was like, no, that's so dumb. It's just a spiral. Why are you carrying two pieces of paper around? And I tried to get all fancy about it, and it just didn't work for me. I just got to write it down and then actually write it down. And so one of the things that really just sucks the life out of me, I don't know about everybody else, are all of the emails that come through. Um, Now clients feel like they need to be able to text you or to send you messages in random places. And so it's really just a matter of making sure that you corral your inbox, keep it all in one place, and then just be diligent, like I said, either at the end of the day or at the end of the week. This is where time blocking is going to be super, super essential.
It's funny you mentioned that, just the old school way of doing stuff. When I was in practice, I just had like this page. It was just, I had a few boxes on it, and I'd put, put the date at the top of the page, and then it'd be like client, ID, and then, TC for telephone call, TC with client resettlement, whatever, 10 minutes or whatever it was, and yeah, it does take time at the end of the day. You kind of got to go through and add it up and all that, but you got a written record of it right there. Sometimes the simpler ways are better, and then you can input it into your time system and do exactly what you said.
Yes, absolutely. We have a comment here about Excel spreadsheets. I will tell you that Excel sheet that was amazing. It was gorgeous. I could sort it. Like Excel is one of my very favorite programs ever. Like I think it's one of the most versatile programs that's been invented. The issue that I started having though is with double entry. And so we have such a limited amount of time anyway. I was finding, okay, so I'm putting it in my book and then I'm putting it in Excel and then I've got to do the invoices. And I was touching it too many times. And so that's where some of these advances that we've had in terms of the matter management programs and the billing software, because there is specialized billing software that's been around forever, like time slips and tab 3. They just are so expensive. And when you're a smaller practice, that can be a little bit intimidating. And they don't always integrate very well with your other programs. And so this is just one of those areas where, you can just play again with what works for you.
Hmm.
So any other thoughts or questions?
Again, this has really been really excellent, man. This is some fantastic information. Good stuff, always.
Well, I really appreciate that. This is one of those areas, it's the money that just scares the hell out of everybody. And it should, because seriously, it's the one area where you could really get sideways, but it's so simple to keep it straight. It's just a matter of making sure that you do it and taking that time. I think as we don't even call ourselves as attorneys, like we don't call ourselves entrepreneurs, but we are. When we open up our own office, that's exactly what we're doing. And you have to take time to work on your business, not just work in your business. And part of that is making sure that your accounting's done, that all of the bookkeeping's done, and that everything is current. And as lawyers, for some reason, our mentality is just not there. But if you take that time, and let's face it, other than our very cool, Fort Bend County Law Library CLEs, nobody wants to be working on a Friday. So you might as well use that to wrap up your week. Let it be a good tie-in for the rest of the things that you're going to be setting yourself up for success in the coming week. And then you can be super happy because everything's there and you've got that sense of accomplishment that it's done.
Right. Yeah. Do your billing on Friday afternoon, and then go for happy hour afterwards.
That's right.
It's actually not too dissimilar to running a library. You got to keep all your accounting and books in order. Of course, trying to deal with county funds is pretty crazy in itself. So,
I can imagine.
well, fortunately, our funds are not tax related issues, but still,
Right.
you still got that accountability you got to worry about, just like dealing with your clients' funds that are not yours, and until you do the job, so to speak, like you said. So, yeah. So,
Yep. Absolutely. Absolutely.
if there's no other questions, thank you very much, Rocky, for another great presentation. And I will have this video to be able to be watched on our YouTube page, which is just Fort Bend County Law Library. So if you came in late to this presentation, you'll be able to see the first part of it as well. And then thank you very much to everybody for joining us, and we'll see you next time.
Awesome. Thanks, y'all.
Thank you.